Good evening, ladies and gentlemen. Welcome to tonight's Board of Appeals hearing. Before we begin, let me introduce some members of this town. Is Peter Hans, a planner in the Planning Department. To his left is John Bongino, Town Building Director. And pretty soon, Valerie Manzo, counsel to the board, will be here. She'll be just a few minutes late. Now let me tell you why you're here tonight. New York State statute requires that any board that adopts zoning must also have a Board of Appeals to act as a relief valve so that those persons aggrieved by strict application of the zoning ordinance can seek relief without the expense of going to court. Town board can give Board of Appeals additional powers such as special exception approvals, site plan approvals, etc. In Smithtown, the town board has given this board authority regarding certificate of existing use and some special exception uses. The most common kind of application before the board are area variances. Area variants deal with dimensions such as lot area, frontage, height, setbacks, and parking spaces. New York State statute mandates that the board must consider the 5 criterion area variances. When you come to the podium to present your application, you need to address these 5 areas. They're posted here for you. Number 1, whether an undesirable change will be produced in the character of the neighborhood or detriment to nearby properties will be created. Number 2, whether the applicant has other feasible alternatives. Number 3, whether the variance is substantial. Number 4, whether an adverse impact on the environment will be created. And number 5, whether the alleged difficulty is self-created. The statute requires the board to balance the interest of the applicant and those of the neighborhood or community. This statute further requires that the board shall grant the minimum variance it shall deem necessary and adequate, and at the same time preserve and protect the character of the neighborhood and the health, safety, and welfare of the community. The board has the power to impose reasonable conditions for granting variances. Special exception applications are different than area variances. When we have a special exception application before us, I will explain the difference. Regarding procedure, cases will be called in order that they are advertised. When your case is called, please come forward, submit your affidavits and mailing receipts to Mr. Hans, and then you will be sworn in at the podium and given the opportunity to explain to this board why you need the variance. If the applicant is done speaking, all interested parties will be given one opportunity and only one opportunity. So please, organize your thoughts. Keep your remarks factual that are related to the case. Then I will ask the applicant to come back to the podium to answer your concerns. The board will then close the case and reserve decision. After all the hearings are closed, the board will review the cases and decide some of them. Others will be reviewed at a later date. There are 3 ways to find out the results of the case. Number 1, you can wait until after the public hearing, but there's no guarantee that the board will act on your case tonight. Number 2, you can call the planning department tomorrow afternoon. And number 3, applicants can wait and be notified by mail. We do have some adjournments tonight, so let me tell you what they are. Case 16440, Smart Mart Express. Was there anyone interested in that case? Okay, that's adjourned to June 28th. And the other case is case 16445, Siri. That's on Gilbert Avenue. Anyone interested in that case? Okay, that's been adjourned to June 28th. First case for tonight. Case 16436, Louis Solano. Location, northwest corner of Attica Road and Longfellow Roads, Kings Park. Property zone R10. Request variance to reduce the minimum rear yard from 35 feet to 30 for an existing 228 square foot addition. Reduce the minimum rear yard from 35 feet to 21 for an existing 561 square foot attached garage. May I have your name, please?
My name is Kevin Finn. I represent Louis Solano. I'm at 500 Front Street, Hempstead, New York. I'm an attorney.
Mr. Finn, would you take the microphone out so that you can,
You can hear me?
yes, please.
I represent Luis Solano. He purchased premises 30 Acacia Road, Kings Park, on April 1st, 2010. He purchased from an estate, premises known as District 800, Section 21, Block 4, lots 40, 41, and 42. I saw in the application you need an exhibit of the deed. I have a copy of the deed to...
I don't think we do, but.
You don't? Okay. Time my client purchased, he did have knowledge that there was a problem. The house, there's a cottage on this premises. It was built prior to 1926. It was a one-family cottage. Then back in 1953, a CO was issued for a 24 by 41 family dwelling. Since that time, there's been 3 additions made. One is a 22 by 10 rear addition. There's a 10 by 16 side addition and a 21 by 28 attached garage. Those structures, I'm told, have been there for well over 30, 40 years. They've existed there. There's a letter also, which I believe you have, from the town of Smithtown, dated October 29, 2009, which my client was aware of, that those problems did exist when he purchased his premises. He was purchasing it for the purpose of fixing up a little bit, renting it out, and his intention was always to legalize these structures. That's why we're here tonight. Again, the request tonight is for a variance under Section 322, subsection 9B of the Building Zoning Ordinance to reduce the minimum rear yard setback from 35 to 30 feet for the rear addition and from 35 feet to 21 feet for the existing 561 square foot attached garage. I submitted the 2 affidavits for the affidavit of posting, also for the mailings. They all came back except for 2, which were not deliverable. I believe the variance should be approved for the following reasons. First, the variance would not have an adverse impact on any adjacent properties. The premises as it exists is 100 by a 220-foot lot. It's on a corner. It's well wooded. There is no, from the additions, there's really no neighbors that close that see it. It's pretty guarded. All the additions are very tightly fitted in with the house. The structures are well built. They fit in with the house. They blend very well into the neighborhood. Secondly, the structures do not affect the health, safety, or welfare of the surrounding owners or the community. They don't alter the character of the neighborhood. As a matter of fact, the structures add to the character. Again, they blend right in with the other houses that I've seen. No other really reason why we're here is no other alternative exists, but really to take the structures down, which would really not be economically feasible. Again, these structures were built many years ago by, I believe, the Gasparo family. They've existed now for approximately 30, 40 years. Fourth, there's no impact on the environment. Structures exist. I did contact the Department of...
Where do you see the 30, 35 to 30?
See if they had the impact.
Where do you see?
Oh, thanks. New York State Department of Environmental Conservation.
You need that to use that mic, please.
Yeah, the New York State Department of Environmental Conservation, I can submit this. They did not require any approvals or permits to approve the property. They said it was solely within your jurisdiction. And finally, the difficulty, my client knew the problem existed when he purchased the premises. He did not create the problem. The problem had been there by the Casaro family 30, 40 years ago when the premises was, the structures were built. And my client purchased the premises with the knowledge that he would have to correct it, which that's why he's here tonight.
Okay. I'm looking at this application. It says 35 to 30. Where is the 30?
the side or the rear addition?
The rear. Yes, go ahead.
It's the portion of the home that's jutting out, it's from the property line.
The 10-foot in the back?
Yeah.
This right
It's
here?
10 by 22 portion, right
Okay,
here.
that's the 30.
Right.
Okay, it wasn't. Okay. Planning? Gentlemen? Okay, thank
All
you
right.
so much.
Thank you, members of the board.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Ridley moved and second. All in favor?
Aye.
Aye. Motion carried. Thank you. Next case is case 16437, John and Josephine Milano, 142 South Placid Avenue, Hauppauge, location west side of South Placid, north of Surin Boulevard, Hauppauge. Let me see where I am. Property zone R10. Request variance to increase the maximum gross floor area from 25%, 28% existing, to 460%, 47% if site did not have environmentally sensitive land. Increase the maximum permitted stories from 2.5 to 3 for proposed additions. Reduce the minimum front yard from 40 to 37 for proposed portico. Permit environmentally sensitive land, depth to groundwater less than 10 feet to be altered.
Good evening, Madam Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. I have offices at 1038 West Jericho Turnpike, Smithtown, New York. I've submitted the affidavits of posting and mailing to Peter Hans. I know at the outset this looks like a very extreme variance as far as the FAR goes. But you do have copies of plans, and there's a couple of elevations, side and I believe rear elevation. And if you would look at that, one of the things that, and I don't know how they get it, but the building department says it's 3 stories. I guess it's 3 stories because it's a split level house, and part of the first floor, at least as far as the back of the house goes, is 3 or 4 feet underground, and then of course as it slopes forward, the front is exposed. So I guess that's the reason for the 3 stories. However, the 3 stories are still within the height requirement of 35 feet. The reason for the variance and the request is that my client's mother-in-law, father-in-law, is about 85 years old, and they want him to come and live with them because he's getting on in years and has a tough time taking care of all of his needs. The father-in-law will be living on the part of the first floor addition. It will also contain a bedroom and a den, and the second floor also will be a master bedroom and bedrooms for the Milano's 3 kids. So the necessity is there. If you look at the site plan shows the addition in the front. There's a portico, and there's a second floor cantilever addition just to kind of make the house even in the front. The rear is where the 2-story addition is, and that's hash marked out so you can readily see it. Even though the addition is about 1,400 square feet on the 2 floors, it doesn't violate side or rear yard setbacks. And of course, You know, because of the fact of environmentally sensitive land, we get this tremendous uh, gross floor area comparison of 460%. It's really 47, but if you take the attic out of the mix here, and you also take the one shed that's included, we bring it down to about 40%. There really isn't any other way to accomplish what we try to accomplish with respect to this application. It will not have an adverse effect on the character of the neighborhood. The benefit sought really can't be done any other way. I mean, obviously, we could make the addition smaller, but if we do that, it would be in a situation where either the kids would have smaller bedrooms, or the father-in-law, Mr. Milano's father-in-law, would be sort of cramped in the new addition. Now, this new addition doesn't contain any cooking facilities. Mr. Milano's father-in-law will be eating at the same table as the Milano family, so this is not the situation where it's a mother and daughter request. The other thing that I'd like to bring to your attention is we do have a McDonald Geoscience test hole data which shows that they don't hit water until 18 feet. So I'm not sure of how the building department come up with the environmentally sensitive land with respect to high groundwater. So I'll just submit this for your perusal. Again, it seems like the variance is substantial, but when you look at the necessity here, I think that the board should give it substantial consideration, given the fact of what the Milanos want to do. Whether the variance would have an adverse effect on impact, physical or environmental impact, there's been an application to the health department. They don't have a problem with sanitary flow, the cesspools. So it's really something that we ask the board to give strong consideration. I know you don't like to go past a certain number on FAR. Another thing I'd like to bring to your attention is that the house directly adjacent is about the same size as this one, maybe a little larger, with the same type of alteration, which Mr. Milano tells me was done 8 or 10 years ago. So we ask the board for its favorable consideration. Mr. Milano's here if you have any questions. Thank you.
Okay. I'm reading it, this house is a little bit over 3,000 square feet. Am I correct?
Total.
Okay. Planning?
No, the only thing I would add is we did see earlier the test hole that was done, and it indicated that depth to groundwater was 18 feet. So I believe the environmentally sensitive land variance is moot at this point. And then as far as the floor area ratios, I'd rely on John for that.
We broke it all down. What brings up the number is a large attic area, height over 5'10", so that makes the percentage, I think, larger than it normally appears.
Madam Chairman, and members of the board, the attic area, I should have mentioned, is just set aside for storage. As you know, in high ranch or split levels, there is no basement, so the only place to store Christmas decorations and summer apparatus is in this attic. We would have no problem in covenanting that that attic would not be used for anything but storage.
What's the square footage of the attic? Do you have it?
In the existing dwelling is 690 square feet, and the proposed addition, 533 square feet.
Yeah.
Mr. Tramarko, I just want to ask, when we looked at the photographs of the existing home, it appeared that nearly half of the first floor, especially in the rear, is below grade, which, you know, is, from a floor area standpoint, sometimes doesn't get calculated into FAR.
Right.
Do you know if they're proposing a regrade? Because when you look at some of the elevations, you know, it looks like a full 3-story exposure with a walkout basement.
I don't believe they're proposing to regrade it.
Okay. From the photos, it looks like the bottom of the grade is coming up nearly
This is
to the
what it
bottom
is
of the
now.
windows. And I was just curious if they were dropping the elevation.
No, that's just the way the terrain of the land exists, and they're not proposing to change it.
So that, but I want to get back to that, 3,000 square feet home is what it is now. It's going to be 47, over 4,700 square feet.
No, that's, I don't believe that's the case. It's, what I think you're reading is the total percentage, 47% of floor area ratio.
What's the total lot area?
That says 36%, right? 4,000.
Yeah, cite that, as proposed.
As
This is
a-
required.
Yep, this is 4,741
5,000, right?
square feet.
It would be about 3,000 with the attic.
Because you're including the attic. 5592.
On the title block, there's a property information box, and basically it says as proposed. If you look at the bottom, it says square footage, FAR. It says as proposed, 4,741 square feet.
And it's a mistake. It can't be that. It's not that.
You see where it is, Mr. Hans?
If it were 4,700 square feet, I haven't got a calculator, but the percentage as against, what is it, 12,000 and change, the
40.
Yeah, you have a calculator with you?
does that come out right, John?
We obtained the percentage at 47. The existing house, with the new additions and the attic space, the square footage comes to 5,592 square feet. The lot size is 12,039 square feet. If you minus the attic,
It works, yes.
if you
I see what
minus
you're
the
saying.
attic, we have it as 1,123 square feet. The total house then is 4,469 square feet.
And minusing the attic would bring us down to probably 41% floor area ratio.
4,469.
Without the attics.
Thanks. Thank you, Peter.
Thanks, Pete.
So I guess what I'm saying, Chairman, members of the board, if we covenanted not to use the attic for anything but storage, as Peter Hans just indicated, we would be down to, if you eliminate the attics, as far as floor area ratio, we'd be down to 37.5%.
Okay. Any other questions, gentlemen?
The lot's 12,038 square feet.
Yes.
Any other questions, gentlemen? No. Thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
Really moved in second. All in favor?
Aye.
Aye. Opposed? Motion carried. Okay. Thank you. Next case is case 16438, Trust of Nancy Verone. Yeah, let's see, is it 264 6th Avenue, St. James? Location northwest corner of Maple Avenue and 6th Avenue, St. James. Property zone R10. Request variance to reduce the minimum front yard from 40 feet to 34 feet for an existing 264 square foot porch.
Good evening. My name is Michael Norton. I'm the agent representing Nancy Verone Trust in place of Hilda Story.
Is the applicant? He does have a power of attorney. Just wait then 1 second, please. Okay, go ahead. Just give us your name and spell your last name, please.
My name is Michael Norton, Norton,
And your address, Michael?
60 Wildwood Drive, Sound Beach, New York.
Okay. Will you raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
I do. I do.
You want to tell us why you're here, please?
I'm here requesting a variance for setback. It's right now we're set up for 40 feet for the setback, and we're looking for 34 feet. Right now, the property is 5 lots. Lots number 559, 558, 557, 556, and 555. There is no undesirable change produced by the existence of the covered porch. It's quite the opposite, actually. It's very appealing, as you can see from the pictures before you. There's obviously no other means that I could achieve what we're looking for, being that the porch is already pre-existing. It's not a substantial request, especially since the property consists of 5 lots. And the house right next to us, which is a corner, the house is actually slightly in front of our house because they have less property, their setback is less. We also have a paper street just to our left, so there's no other property adjoining us except on the other side of the paper street. It wouldn't be a substantial request, especially since the property does consist of 5 lots. There would be no adverse impact on the physical environment, being that there was a brick patio pre-existing the porch. So that property was already covered, with the exception of the porch area, the roof. As far as whether it was allegedly, if it was self-created, the problem, as you know, this is a trust. The homeowner is deceased, and I'm acting on behalf of the homeowner's mother. I do have a bill from when it was built, and it was built 11 years ago. Now, she would have had to do the same thing at that time. If she wanted to have a covered porch, we would have had to come in front of the zoning board for a variance anyway. So I really don't think that that would have been too much of a problem at that point, because we would have had to do the same thing.
Planning? Gentlemen? Okay, thank you so much.
Thank you, ma'am.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
It's regularly moved in second. All in favor?
Aye.
Aye. Motion carried. Next case is case 16439, Peter Scalava, 1 Grandview Lane. Location, northwest corner of Grandview Lane and Old Willets Path, Smithtown, property zone R43. Request variance to reduce the minimum side yard from 24 feet to 9 for an existing 140 square foot shed.
Madam Chairman, members of the board, my name is Vincent DeMarco. I represent the applicant. I have, well, you know where I have the offices. If you take a look at the survey,
Mr. Marco, use the mic, please.
you can't hear me?
Yeah.
If you take a look at the survey, you'll see where the shed is located. This shed existed for many years. What happened basically last year, my clients threw down their existing house and built a new house on the property. The only thing that they saved was the existing pool, which of course was permitted, and this shed, which wasn't. The shed is on the west side of the property. It is well along that boundary line. There is trees and shrubs and the like, so it really can't be seen from the dwelling immediately to the west of the subject property. This property is a corner piece. It fronts on Old Willets and on Grandview Lane, as you can see. The shed is almost imperceptible if you're riding down Grandview Lane, and you certainly can't see it from Old Willets Path. It would not have an adverse effect on the character of the area. As I said, my clients recently built this new house, and the only thing they saved was this shed and an existing pool. Whether the benefit sought could be achieved by some other method, the only other method would be to remove the shed and rebuild it or relocate it to the rear of the property. Whether the requested variance, area variance, is substantial. Well, that side yard is supposed to be 24. It ends up being 9 point something. Again, it has no effect because the dwelling to the west can't even see it. And I don't know if anybody could see it from Grandview Lane. As I said, it's almost invisible. Whether the proposed variance will have an adverse effect on the physical or environmental conditions of the neighborhood or the district, no, it won't. This is a residential area, and everybody has sheds. Whether the alleged difficulty was self-created, yes, it was. It was built many years ago with the old house, and obviously it was built without a permit. We're asking the board to grant this variance so we can maintain the shed. Thank you.
Thank you. Planning? Gentlemen?
No question.
Thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Regularly moved in second. All in favor?
Aye.
Aye. Opposed? Motion carried. Next case, case 16440, Smart Mart Express, has been adjourned to June 28th. Next case is case 16441, AAA Properties LLC, 797 Middle Country Road, St. James. Location: north side of Middle Country Road, west of Astor Avenue, St. James. Property zone WSI. Ladies and gentlemen, this is a special exception. With a special exception, it is a permitted use. If they meet all the criteria, then this board has to approve it. If they do not meet the criteria, or the criteria for a special exception, then they have to ask for variances or to waive the special exception standard. All right? So let me continue with this. Special exception to permit parking in resident district. Special exception to permit repair garage. Now this is what they're waiving. Waive special exception standard that requires lot area to be adequate. Waive special exception standard that requires adequate parking. Waive special exception standard that requires adequate buffer yards and screening. Waive special exception standards that requires lot to be in existence prior to the adoption of zoning line. Reduce minimum landscaping area between parking and front property line from 8% to 3.7%, 4% existing. Reduce the minimum parking from 90 spaces to 54, and reduce the minimum truck loading spaces from 1 to 0. Reduce the minimum parking setback from front property line from 20 feet to 6, 8 feet existing. And reduce the minimum parking setback from side property line from 6 feet to 0. Variance to reduce buffer to the resident district from 10 feet to 0. Vary standard that requires floor area to be less than 25% of lot area, 31% requested. Vary standard that requires 50% buffer, 18 feet buffer in residential district required. Is that a mouthful?
That was a mouthful, huh? Madam Chairman, members of the board, my name is Vincent Tremarco. I represent the applicant. I've submitted the affidavits of posting and mailing to Peter Hans. Just a little bit of background. This building was purchased by my client some years ago, and when he purchased it, or AAA Properties LLC purchased it, the two repair garages were in force and operating. One was a tire mounting and sales place, and the other was a windshield replacement company. The third use was a karate school that has since gone out of business. So we do have those two special exceptions that we're requesting. Again, I want to emphasize that when my client bought this, these two uses were well into operation. The building is similar to a building that's just to the west of this particular building, and this board gave similar variances probably, I don't know, 5 or 6 months ago, and that building contained, I believe, a king bear, a now defunct adult video store, and I can't remember what the third use was. But the board saw fit to allow a certain amount of latitude with respect to these applications, only because in that case, as well as in this case, they've been in operation for many years. If you look at some of the variances, the parking variance is really minuscule. It's from 63 to 54 spaces. Truck loading spaces are routinely varied, and in this case from 1 to 0. There's plenty of space in the back of the property, and there are overhead doors in the back where trucks pull in and out in order to unload. The landscaped area in the front, again, 4% landscaping was existing for many years, and the building initially was CO'd with that landscaping that you see today. I've spoken to my client, and he doesn't have a problem with adding some additional landscaping if the board so required it. The The parking setback from the property line from 20 feet to 6 foot, there's 8 foot existing. One of the things that you should take cognizance of is this is a split zone piece of property, and in the rear of the property, the zoning line, if you see that hatch mark in the site plan, it's split zoned, and the zoning line is a dashed line, and you have residential property that's part of my client's property, and we're asking to go into that property for parking, but not in any substantial manner. Again, if you look at the site plan, you'll see it's minimal, to say the least. The balance of that residential parcel is lawn and trees, and it's been, I guess, no, it has been that way for many, many, many years. We believe, we believe the lot area is adequate, given the fact that it's been in operation for so many years. There's never been any issue with respect to parking or overcrowding of vehicles or outside storage issues. It's always been more than adequate. Again, talks about lot area, but it also says that requires parking to be adequate. That property has never been full. There's always been adequate parking, and there has never been a complaint, at least as far as we know, with respect to the issue of parking. The floor area ratio requested is from 25% to 31 requested. Again, when you think about what's being done over there, all that work, by the way, is indoors. The tire shop and the glass windshield company, whatever work is being done at the site is done inside. It's not done outside. The glass place usually goes on site to repair windshields. But whatever else is done, it's done indoors. The special exception requirement, we're asking for a variance for a 50-foot buffer adjacent to a residential district. Again, it's been that way for many, many years. We're asking for an 18-foot buffer. I don't think that my client would have a problem if you require some additional landscaping in the back, as you might in the front. So we would be amenable to that. The variance to waive the special exception that requires the lot to be in existence prior to the adoption of zoning. Obviously, we have to ask for a variance because the lots, I don't believe, were in existence prior to zoning. They're probably part of an old file map, but not one that was prior to 32. So we asked the board for its favorable consideration. I don't know if you want me to go through all of the criteria.
One of the things is a secret determination has not been completed from the environmental department, so the board can't act anyway. In addition, the planning department did not complete the planning advisory report in time for tonight's meeting. However, review of the plans, I mean, the office has reviewed the plans, and I would agree with Mr. Tremarco's assessment. You know, we've compared it to the approved site plan. The front landscape area essentially matches the approved site plan. The problem was in the rear. You can see where the approved parking ended with the dash line. That was extended approximately 36 to 40 feet. And basically, I believe the planning director is, you know, leaning towards recommending approval with conditions that several site enhancements be done. The other thing we just noticed comparing the plans, the third tenant space, you're proposing right now, I believe, wholesale business. At one time when the denial was prepared, they were proposing a karate studio. Do you know if that's still in the works? The reason
I
I'm
thought I
asking,
indicated that they went out of business, so we don't have any
Okay.
tenant now. So whatever is permitted in the WSI zone,
well, they're both permitted. The reason I ask is there's different parking ratios, and the way the advertisement is written, it's more substantial for the karate studio. It's from 90 to 54, whereas, because it's at a 1 per 100, whereas a wholesale business is 1 per 250. The advertisement's written to reduce the parking from 90 to 54. If you're leaning towards the wholesale business route, then we're only looking at a variance reduction from 63 to 54. So that's why I bring it up.
yeah, that's what we're looking at.
Okay. Other than that, you know, we should have a report prepared for the board at the next meeting. The other thing we might say is the 2 repair garages that are there. You know, as Mr. Tramarco said, everything is, for the most part, indoors. There are no outdoor storage yards. From the numerous inspections by our department, the parking lot appears to be heavily underutilized, so we don't believe that there really is a parking issue. And it doesn't appear that there's a lot of noise from the either Safelite or the tire company. Thank you.
I'd just like to add that we don't believe that it would, if you grant these variances and permit the special exceptions, that it will be an undesirable change in the character of the area, given the fact that it is a commercial area. As I indicated, the building to the west is almost a mirror image of our building, and to the east, there are again commercial buildings. Can the benefit be achieved by some other method? No, the buildings have been built since the 80s. This building has been built since the 80s, and there's really no other way to work this out other than to ask this board to grant us these special exceptions and variances, which should have been done many years ago, and they weren't. Whether the requested area variance is substantial, we think not, given the site and given the fact that we have substantial parking. Whether it would have an impact on the physical or environmental conditions in the neighborhood, no, it's, these are strictly businesses, as I said, a tire place and a windshield replacement place. The only environmental issues would be if there was a substantial use of the sanitary system, and there isn't. They're just bathrooms for the employees. And was the difficulty self-created? Not in this case with respect to my client, who thought he was buying a building that was all approved. Thank you.
Okay, thank you. Is there anyone here that would like to be heard on this application? Come up, please. May I have your name, please?
Robert Frenna, F-R-E-N-N-A.
And your address, please.
10 Hope Place, St. James, New York. I'm the property directly behind, I share the same property line as this building.
First of all, let me swear you in.
Okay,
Would you raise your right hand, please? Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
My building hasn't moved, I'm still the property behind his.
Okay, good.
The building is a good neighbor in the sense they're clean and they do maintain their property, so,
You address this board.
okay. I do have some disagreement with what's been said as far as no activity. It is quite noisy. They do work at night. They open up the garage door in the summer, it stays open, the radios blare, the guys are hooting and hollering, they're working. They take the broken glass, they throw it in the dumpster, it sounds like a bomb goes off. So there is an acoustical impact of the neighbor. There's a visual impact in that there is no buffer in terms of a tree. There's a 6-foot fence in the backyard. And the lawn area that was described is in fact a lawn area, but there is no visual buffer. So when the trucks come in at night, they pull in, and then they back up to the building, the entire back of my house lights up. It would, if the, you know, given that the building next door got approved, and I believe I was at that meeting too, and I heard that there was going to be dense, you know, a buffer plant that would stop some of the visual and acoustical impact. That's, to me, very necessary. There isn't a single evergreen on that back of that property, so there is nothing to stop anything. There's an oak tree, but, you know, that's 75 feet tall. As far as when the trucks park in the back, it's a visual. You see the trucks, they park, they look like they're parked in your backyard, because you see, you know, when they park the vans, you see the whole top of the van. When the box truck gets parked, it looks like it's in your yard. You can't stop the kids are back there, because I gauge that by the amount of beer bottles in the backyard that I got to clean up on a weekly basis. So I asked this board that if you're considering this, which probably will happen, if you could some way put a buffer there. I'm assuming there's no changes to the current curb line. That's what I think I heard.
Right.
All right, it's going to make what is legal. If a buffer could be planted there, I think that would be a decent compromise in the sense that, you know, as a homeowner, it would be nice to have some kind of separation between them. And hopefully not a 3-foot evergreen, because it would probably take 20 years to grow, but that is what it is. Thank you very much.
Thank you. Anyone else? Come up, please. May I have
Good
your name,
evening.
please?
My name is Michael DiPaolo. I live at 6 Hope Place, And
Spell your last name.
DIPALO.
Okay, raise your right hand. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do. Same thing that John said, that I live right behind there. I actually live behind King Bear, and they do leave the garage doors wide open. The air impact guns are going off. The radios are blaring. Guys are yelling. They got intercoms that are just going off. There are no buffer zones. I actually been planting Leland cypress trees to try to grow back there, to try to cover up the noise because it's so loud. And as John said, the glass place at night, 6 o'clock in the morning, they're throwing glass out in their dumpsters, and it sounds like, you know, someone's breaking into my house. The tow trucks that are going back there, just very noisy. A lot of light, a lot of noise, like John said.
Where's the light coming
From the tow trucks as they're backing up and dropping off cars and whatnot. There's a lot of activity going down there late at night. Sometimes 2 o'clock in the morning, there might be trucks going back there, making noise. They're running constantly. They're not shutting their engines off. I don't know. He says that he doesn't get a lot of debris. I get a lot of debris in my house, in my backyard. I get peepers, rubber gloves, tons of stuff just coming over the fence, and I guess the landscaping blowing, whatever they're doing over there. You know, I have a child on the way, so I'm going to have a newborn soon, and I'm just trying to, you know, look out for my own beneficiary.
Okay.
So I'm just hoping that they're not going to reduce the buffer zone in the back and pull it closer to the fence. Maybe they could, you know, like they were saying, put more shrubbery back there and try to cut the noise down. And, you know, especially, you know, with the trucks at night, it's just really loud. So, all right. Thank you.
Thank you. Anyone else? Mr. Tramarko?
Well, of course, I can't speak for the King Bear building, but I did speak with my client, and he would be amenable to reasonable buffering in the back. I understand that grass doesn't buffer, so whatever this board decides, as long as it's within the realm of reasonableness, we certainly want to be a good neighbor. And we
Why
wanna-
are tow trucks going in at 2 o'clock in the morning?
I'm glad you said that. I don't think they're going into my client's property, because my client has has two tenants. They're a tire installation place and a glass, as I said, glass windshield place. Maybe, and I'm not sure, but maybe it's going into King Bear because they do repair work I don't know. Chances of tow trucks coming in the back of our place, this doesn't make any sense. Now, there may be other trucks that are dropping off inventory and supplies. That may be the case. I don't know.
Okay. Anybody, anything else, gentlemen? Okay.
No.
Thank you.
Thank you. Okay. I'll entertain a motion, to close the hearing.
So moved.
Mr. Tramarko, just let me ask you a question. The PAR is not done. Do you want this to be adjourned? Yeah. Okay. So you have a right, you have a time to,
The next meeting?
yeah. All right. That'll be the last one for, then I'll adjourn it to June 28th, I'm sorry.
Thank you.
Okay. Okay, do you understand what I'm doing? It's being adjourned. Well, first of all, there was no secret, so there was no action tonight anyway. But I'm adjourning it to the next meeting, which is June 28th, so that the recommendations from the planning department, the applicant can read them and answer any questions we have. Okay? You're welcome. Can I give everything, Kat? Next case is case 16442, Robert and Kelly Wrights, 24 Lower Road, Smithtown location, west side of Lower Road, south of Oakside Road, Smithtown, property zone R21. Request variance to reduce the setback of a 5-foot fence from a retaining wall from 11 feet to 0 feet existing. Increase the maximum height of a wall fence from 6 feet to 16. Reduce the minimum distance of a wall fence from any lot line from 16 feet to 0. Permit environmentally sensitive land slopes in excess of 15% to be altered. Permit retaining walls within 10 feet of any slope higher than 15%. Reduce the minimum front yard from 50 feet to 48 for a porch within 10 feet of any slope higher than 15%. I said all that, okay? And reduce the minimum front yard from 50 feet to 48 for a porch.
Hi.
Hi, may I have your name, please?
Hi, I'm Kelly Trites.
Put that mic right by you.
I tried. Kelly Trites,
Okay, Kelly, and your address, please.
24 Lower Road. I own the house.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
And I do.
Are you doing all the talking?
I am.
You say yes. Okay.
I'm gonna
Because if
try.
he wants to speak, I have to swear him in. All right. All right, you want to tell us why you're here, please?
Sure. We purchased our house about 1.5 years ago. Unannounced to us, we thought all the house had all of the permits that it should have had, and it doesn't. The house was built about 10 years ago. It was originally built with a front porch on it. About 6 years after that, about 4 years after that, they had added on I don't know the exact size of it, but they had added on a little extra part of the porch that slightly wraps around the side of the house, which is, from what we understand, 2 feet too close to the curb. Also, there is a retaining wall that is in the backyard of our house that we can't see from our backyard. It actually sits underneath our backyard. It holds up the backyard. It's 2 levels, one of which I believe is 4 feet. Then there's about a 4-foot I guess, level point, and then it's another 6 feet tall. I'm sorry.
That's okay.
Like I said, the wall has been there. From what our neighbors tell us, the wall has been there for at least the past 6 years. They, from what we understand, when the pool was put in, which we have a permit for in 2005, they said that the wall was there, otherwise the pool wouldn't have been able to be level with the rest of the backyard. In the spring, summer, I guess early fall, you can't even see the wall because it's all covered in shrubs and ivy. The wall faces an empty lot, an empty wooded lot that I don't know anybody that ever goes down there. It's a really tall, really steep incline to get down to where that wall is as well. If we had to take that wall down, our backyard would collapse. Financially, it would be a huge hardship, to say the least. We have gotten a letter, which I think you guys have, from the highway department, because I understand that the wall is also in a drainage easement. It's in 10 feet of a 20-foot drainage easement. We got a letter from the highway department saying that it was okay, that it's there, but we had to give permission for them if they ever needed to knock it down for whatever work they might have to do, that they would be able to do that. I also have a letter from our architect who, we have been working with engineering as well to make sure that the wall is structurally sound. Just the other day I got a letter from them stating that that wall is, from what he can tell of, he didn't build it, but from what he can tell, that it is structurally sound. Both things, both the wall and the porch, they're already there. Nobody in our neighborhood seems to have a problem with it, nor can you see it, like I said. Like I said, for us to take it down would be a huge financial hardship. It would also disrupt my whole backyard. And like I said, it was self-created wasn't by us, but by the people that owned the house prior to us.
Just a couple of questions.
Sure.
First of all, we want you to know that we do visit the sites.
Yes.
And so I know that some of the board members did visit the site. It is very steep. You have an estate fence, that black
Yes, like
fence.
a
Is that
iron fence.
remaining? You're not replacing
No,
it
we're not.
with
We
any
would
other
like
kind
not
of
to do
fence, are you?
We would not.
Okay. I don't think planning has anything. Gentlemen?
No.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
It's readily moved in second. All in favor?
Aye.
Aye. Motion carried.
Thank you.
Next case is case 1443, Christine and Daniel Rinaldo. 16443. 7 Nancy Lane, Wisconsin. Location, east side of Nancy Lane, west of Nichols Road, Wisconsin. Property zone R10. Variance to increase the FAR from 25% to 30% for a proposed 25 square foot first floor addition and a proposed 240 square foot second floor addition. And your name, please?
Christine Ronaldo,
And your address, Christine.
7 Nancy Lane.
Okay, raise your right hand, please. You swear to tell the whole truth and nothing but the truth.
Yes, I do.
Thank you.
Okay. Well, I'm not professional like these other guys, so I really don't know what to say. I'm just going to start with what's on that board over there and answer those
Sure,
questions.
Fine. Just tell us what
Okay.
you're doing and then.
Okay,
Go
I'd like
over
to
those.
build a bedroom on the second floor
Okay.
for my mother who became ill over the summer and has to live with me now. Okay, so I need to build her a bedroom. I'd like to extend my kitchen out 25 feet, 25 square feet, so that we can all sit at the kitchen table together without having to push it around. I don't believe that it's going to cause any, just make the neighborhood nasty looking. It's in the back of the house. What else? I don't believe there's any other choice in the matter, since I only have a 4-bedroom house and I have 3 teenagers, and I have 2 sharing a room right now, one sleeping on the floor for the last 8 months, and my mother using his room. So we really need to get this going. I believe that it's substantial. The reason? No, I don't believe. I don't know.
Good.
All right, so, and I don't believe it has any environmental effects. And I guess that's it.
And you haven't done it yet, so it's not self-created?
Oh, no, I haven't done it yet.
Okay.
All right.
All right. Planning? Gentlemen?
No.
Okay, thank you so much. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
All in favor?
Aye.
Aye, motion carried. All right. Next case is case 16444. Is it Lewick? Lewick? Karine Bardu? Bardu. All right. 39 Hilltop Drive, Smithtown, location, east side of Hilltop Drive, south of Poplar Drive, Smithtown, property zone R21. Request variance to increase the maximum paved surfaces in front yard from 25% to 33%. May I have your name and address, please?
Sure. Karine Barbu. Karine Barbu, B-A-R-B-O-U, 39 Hilltop Drive in Smithtown.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Are you doing all the talking also?
Pretty much. I think so.
Okay. If you're going to talk, then I'm going to swear you in later, all right? Okay. You want to tell us why you're here, please?
Sure. We purchased the house back in November of last year, of 2010. We knew that there was an issue with the driveway. At the time, though, the owner did say that everything was going to be settled. You know, he was taking care of everything with, I guess, the building department. He was aware that there was a slight difference in the amount of pavement. However, it was brought to our attention that the reason for that was that everything was approved. He went ahead with the pavement. And then, once everything was checked out, that's when they saw that when the layout was done of the land, that they saw that there was a difference. In any case, we went ahead, purchased the property. Again, at the time, we were told, we were issued the CO, said normally that there was no issue or anything like that. We were contacted, Gloria Brown, I believe Gloria Brown is her name, in the planning department. Very nice, communicated back and forth.
Gloria Charles, yeah.
Thank you, Gloria, yes. Communicated back and forth with her. She was very helpful in getting us the information and everything else like that. And we want to go ahead and just fix the situation, obtain the variance. As you may see from the pictures, the driveway is very nicely done, very tastefully done. He did everything very nicely, the previous homeowner. It would almost be like taking out a slice of pizza then from the pavement, from the driveway in the front, extending to the rear. It would be costly on our end as well, especially since we did just move into the property. It was something that, once again, we thought was taken care of, unfortunately. Basically, there's no undesirable change. I should say, if it was to be taken out, that specific amount of the pavement there, it probably wouldn't look very nice at all. You know, if we had to go through all that and go through whatever else that need to be done, put dirt there, put grass there, and it would divide the two pieces then. And that's what we would have to do, basically, is take out the pavement that's there and create something that would not be very nice. Not substantial, as far as I know. If we're increasing it from 25 to 33%, it does look very nice the way it is right now, the way he did it. It does not have any adverse reaction. In fact, I think everybody who were to see it, or any of the neighbors or anything like that, they seem to be very happy with the property as well. And it was not self-created by us, it was self-created by the previous owner.
Planning? Gentlemen?
No.
No question.
Okay, thank you
Okay.
so much.
Thank you.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
Really moved in second. All in favor?
Aye.
Motion carried. Case 16445 has been adjourned to June 28th. Case 16446, Patricia Couture, 16 Mountain Laurel Lane, Kings Park. Location, south side of Mountain Laurel Lane, west of Twin Oaks Drive, Kings Park, property zone R10. Request variance to reduce the setback of a wall to property line from 3 feet to 0 feet existing. Reduce the minimum setback of a retaining wall from 4 feet to 0. Increase the maximum fence wall height from 6 feet to 10 feet. Permit environmentally sensitive land to be altered. Permit structures within 10 feet of any slope more than 15%. And your name, please.
Patricia Couture. Patricia Couture,
And your address, Patricia.
16 Mountain Laurel Lane, Kings Park, New York.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Would you like this gentleman to speak for you? It's up to you.
No, I'll do it.
Oh, you're going to do it. Okay.
Yeah, this.
I can help him, maybe.
Okay, good. You want to tell us why you're here, please?
Yes, I have an existing retaining wall that's been there about 10 years, a little bit more. It's a 4-foot retaining wall that was built to make a play area for the children. It has gravel in it, and there's also a fence on top of it. It's been great for my neighbors, no water, because if we would take it down, it would slope, and it would be a drainage issue for my neighbor. I'm recently selling my house, so also this is why I need the variance. It looks nice. Yeah, oh, I have a letter from my neighbor who wanted to come on my behalf but couldn't make it.
That's quite all right. A lot of us do. Okay, anything else you want to add?
No,
Okay.
thank you.
Planning?
Overall, I think we were okay. We were just primarily concerned about the impact on the adjacent neighbor of the 6-foot fence on top of a 4-foot wall. Essentially, you have a 10-foot high wall that they're looking at. Typically, the board would recommend, moving the fence back a couple feet from the top of the wall so that landscaping could be put in there to soften it up. But that's the only comment I offer.
The neighbor gave me a letter, they would have appeared on my behalf, that it's been there, they have no problem with it. It
But the
enhances-
neighbor can change, It really isn't fair for a neighbor to be looking at a wall that is so high. I don't know how the other board members feel, but usually we do ask you to move that fence back into landscape just to soften.
Okay,
But I don't know what the decision's going to be,
okay,
all right?
thank you.
You're welcome. Anything else, gentlemen, is there anything you want to add? Okay. All right, thank you. Okay. Next case is case 1. Oh, I'm sorry, I didn't close it. Entertain a motion to close the hearing.
So moved.
Second.
Billy moves in second. All in favor? Aye. Opposed? Motion carried. You're welcome. Next case is case 16447, Darrell and Michelle Valvin. Spell your last name. Say it. Valinchis, okay. 14 Bristol Lane, Kings Park. Location, southwest corner of Dead Place and Bristol Lanes, Kings Park, property zone R10. Request Reduce minimum side yard from 12 feet to 8 feet, proposed 355 square foot addition. Variance to reduce the minimum distance from any lot line from 6 feet to 4, and for an existing 120 square foot shed. Reduce the minimum distance from any lot line from 6 feet to 3 feet for an existing above-ground pool with deck. And your name, please.
Darrell Valentius,
And your address, Darrell.
14 Bristol Lane, Kings Park, New York.
Okay, raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Thank you.
Thank you.
Do you want to tell us why you're here, please?
Absolutely. I'm here for some variances, and I kind of followed your structure here, so hopefully I take care of it the right way. The variances that I'm requesting would not affect the adjacent properties in the neighborhood because it's not going to deviate from an existing one-family house. We're looking to add on a one-car garage, and there are numerous houses in the neighborhood that have two-car garages. The requested proposal is not substantial because it is only a one-story, one-car garage, and the height would not encroach, it would only encroach into the side yard 4 feet more than what we would be allowed to. So in other words, we're only allowed to go within 12 feet of a line. We're asking you to give us the variance to go within 8 feet of the line. I cannot achieve this any other way. I'm on a corner property. My garage is situated on that side of the property, and other side yards I have are considered front yards that really would not, it would deviate from the way the neighborhood looks if I tried to put a one-car garage over there. The difficulty, well, was and was not created by myself. The new structure that I'm looking to create and build would not be a problem. The pool, that was my self-infliction. I did not know there was a setback from the fence in the rear of the house. And there is a pre-existing shed, which is in the back of the house now, that was there when I purchased the house.
That's still your problem.
It's my problem, but I didn't create it this time.
Well,
But it's still my problem.
Yeah.
It is in front of a telephone pole or electric pole back there, so I'd rather hopefully look at my shed. If we added this one-car garage, that shed would not be visible from the front of the house any longer. And right now, the property is surrounded by a fence, 6 foot along the sides, except in the front area where it has to be 4 foot. Thank you.
okay. I see you're extending the garage out further than the house, huh?
Further back, yes, ma'am.
Further back?
I have a large piece of property back there. If I'm only going the width, I'd like to go, I'm only going back 6 more feet than the house exists right now.
Planning? Gentlemen?
No thanks.
No question.
Okay.
Thank you.
Thank you so much. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
It's freezing in here. Is it freezing? I said it's freezing in here. All right, we'll be going to the back now to the adjourned hearings. Case 16284, Susan and Paul Baker, 28 Allenbine Drive, Fort Salonga location.
I don't have my, I was here in October, and they were sent home, my letters, everything I just throw in here, I got 2 that were returned to me.
All right, wait a minute. Yeah, you don't have, Val,
I've had 3 signs, I've been called in October,
I know that.
January,
I know it. What happened was, we adjourned this case a couple of times because we knew that the ordinance was going to be amended. Now, she sent out, you sent out all your cards the first time. Right.
Right.
And we kept adjourning it. So I think all she had to do was put up the sign and change the date. Am I correct?
Yes, correct. She still has to sign the affidavit that she did that.
Right.
Okay.
Now, you don't have the affidavits with, do you have the affidavits?
The affidavit of posting, that just says that you put the sign up. Sometimes we have a blank. Do you have a blank? We may have a blank one that you can fill it out now. You're just going to swear that you did. And we need somebody who's a notary.
I have one attorney. That's all right. I
Oh,
don't think
you
you
have
have
to-
to, I don't
you
think you have to put on this record on this. She's just confused with what she had to do.
You didn't do any one of these in the last couple of days, right?
No. That I didn't know, I just posted it.
Right. So we would need this completed, that's it.
That's it.
So we would
Yes.
need a notary to do that.
Correct.
Yeah, and we have an attorney in the back, so he
You?
may do it for you. All right,
Okay.
I'll hear the case.
Well, you have to have his notary stamp with him, though.
What?
You mean Mr. Altman?
Yes.
Do you have your notary stamp, Mr. Altman? Oh, okay. Good enough. Doesn't have to be a stamp. Just have to know the number.
All right, come up here now. All right. It's okay. Okay. So let me go back.
Okay.
You want me to start all over again?
Sorry, everyone.
Case 16284, Susan and Paul Baker,
Yes.
28
Allenby.
Allenby Drive, Fort Salonga, location, north side of Sound Road, east of Allenby Drive, Fort Salonga, property zone R43.
Yes.
Request variance to reduce the minimum side yard from 24 feet to 5 feet for an existing 96 square foot shed. Permit a 96 square foot shed within 100 feet from an escarpment. Okay, let me have your name
Susan Baker,
and your address.
28 Allenby Drive, Fort Salonga, 11768.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Okay.
All right. We had a pool put in our home about, I'm going to say 2005. Our existing home, which we purchased, was already on the setbacks of the 24 feet. And I thought that the setback for a shed was 10 feet, actually, so that's my goof. But had we put the shed and the 24 feet, well, let me just, first of all, it does not any undesirable change. It's a very pretty shed. It does not change the character. As a matter of fact, it enhances the backyard, I think, greatly. It wouldn't have been feasible to put it anyplace else. Had we put it at the 24 feet on the west side of the property and back the 100 feet, it would have been basically right on top of the house. On the east side of the property, it's very hilly, and that is also, and it would not have been feasible to put it there. It's just a simple square 8 by 12 box that sits on top of the property. There's no electricity, plumbing, anything like that. It's set on an angle. It was supposed to be put in at 10. Like I said, that was my goof. I thought it was a 10-foot setback for the small shed. But the people that put it in, it was closer. On the neighbor's property, there's a row of arborvitaes, and this is tucked into our property with large evergreens. So it's very nice looking. It does not have an adverse effect on the environment or the neighborhood. I don't think anyone can see it from my neighbors. And I guess it was self-created. I put it in there, but there was really no place else to put it, and we really needed some storage for the pool cover when it comes off, and rather than just having that sitting in the yard and things that have to go away in the wintertime.
Okay.
So that's pretty much it, just my simple little box shed.
Okay.
And
Planning?
it's pretty.
No, the only thing I would add is I was advised by Allison in our office that the LWRP was completed.
It was completed and approved?
Yes.
Okay.
Just have to fill it out. Okay. And Mr. Altman. No, you should do it in pen. Here, you can borrow. Okay. Okay. And then, yeah, and he'll know.
Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second.
Rarely moved in second. Motion carried. Next case is case 16425, Christine DeMonte, 4 Higbee Drive, Smithtown, location southwest corner of Higbee Drive and Juniper Avenue, Smithtown, property zone R10. Request variance to increase the maximum gross floor area of a lot from 25% to 38%. Reduce the minimum front yard on Higbee Drive from 25 feet to 16 feet for a 2-story addition. Reduce the minimum side yard west from 12 feet to 11 feet existing. Increase the maximum paving in side yard from 25% to 53%. Reduce the front yard setback on Higbee Drive from 25 feet to 6 feet for a 49 square foot shed. May I have your name, please?
Christy DeMonte,
And your address, Christine?
4 Higbee Drive in Smithtown.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do. I'm going to have Frank speak on my behalf.
I'm sorry?
Frank speak on my behalf, my architect.
Sure.
Thanks.
May I have your name, please?
Frank Restituto,
Spell your last name.
R-E-S-T-I-T-U-T-O.
Okay. Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
I do.
Did you give me your address?
18 Crabapple Lane, Comac.
Okay.
The matter at hand is the construction of an addition to an existing residence at the southwest corner of Higbee Drive and Juniper Avenue. We appreciate the board's decision to adjourn the previous hearing on May 24th to June 14th, which gave us an opportunity to review the floor area ratio requirements for this project as it affects the overall square footage of the proposed additions. Currently, the existing residence consists of 1,972 square feet. The proposed first and second floor additions of 2,662 square feet, plus the open first floor porch consisting of 228 square feet, and the attic space above the second floor consisting of 243 square feet, brings the total residence to 5,346 square feet. When divided by the site area of 15,045 square feet, the floor area ratio is 35% of the overall site. If the board would give consideration to eliminating the open porch on the first floor and the second floor attic space from the floor area ratio calculation, the ratio is then reduced to 30% of the site coverage, which is much closer to the planning board's maximum requirement of 25%. The attic and porch do not significantly impact on the overall visual volume of the proposed structure. However, if the board saw fit to include the attic area in the floor area calculation, the ratio would then become 32% of site coverage, again, less than the 35 originally requested. Your consideration to either of these two variance requests is greatly appreciated. My client wishes to advise the board that the existing plastic shed on Higbee Drive has been removed and relocated.
Planning?
You want me to be the tough one?
Yeah, I guess I'm going to.
The planning director asked me to relay a message. He was concerned about the bulk and the size of the structure and its close proximity off of Higbee Drive. And his recommendation was possibly reducing the structure by 5 feet to be 24 by 25 as opposed to 24 by 30. Therefore, the reduction to Higbee Drive wouldn't be as severe. He also suggested doing something, over the garage, perhaps using dormers so that it didn't look like a 2.5-story addition, but more like a, 2-story addition. Those were the suggestions that he asked that I relay to the board. He was primarily concerned about the addition being so close to Higbee Drive.
Are we talking about reducing the length of the garage?
Yeah, the survey is proposing a 24 by 30 addition. He was saying if it was shortened 5 feet in width, it would still give you a 2-car garage, but it wouldn't come as close to Higbee Drive. Yeah, it reduces each floor by approximately 120 square feet. So,
Yeah, the point that we had made at the previous hearing was that it's only a corner of the garage that is encroaching on the Higbee Drive, and it angles off on both sides.
I understand. I think it was just the combination of the closeness to Higbee plus the height of the proposed structure. If it was a 1-story or even a 2-story addition, I think he was saying it wouldn't be as severe. But he just felt it was a large addition so close to the road. But certainly it's the board's determination.
Am I understanding then you're suggesting that the setback be 20 feet instead of the 16'8"?
That was one of the recommendations of the director.
Mm-hmm. I have to tell you, I'm still concerned about you having a staircase going up to this office that you consider, or now what you could say is a computer room. I don't understand why you need that staircase.
Can I have somebody speak on my behalf also? Right behind me? Joe Sorty?
Go right ahead.
Thank you.
Let me swear you in, please.
Sure.
Let me have your name and address, please.
Hi, Joseph Sordi, 4 Higbee.
Say your last name.
S-O-R-D-I, 4 Higbee Drive, Smithtown, domestic partner of Christie's.
Raise your right hand, please. Do you swear to tell the whole truth and nothing but the truth?
Yes, I do.
Use the mic and take it out, please.
Sure, no problem. In reference to your question regarding the outdoor staircase, that is just kind of to basically enable Christy, who does accounting, to have a separate entrance so that late at night, she comes home at 11 o'clock at night, she comes home at 12 o'clock at night. A lot of times she does a lot of work from home during tax season. And that, coupled with the 3 kids that I have from a previous marriage, which don't penalize her for, but the additional kids that we will have, the access to come in a back way and also to entertain a private client every now and then, occasionally during tax season, would be the reason for that staircase. Set this way because otherwise she'd be going right through the kids' bedrooms to bring files up to the office or whatever it is. And the kids are 9, 7, and 6, 9, 7, and 5.
You can't walk through the house, the front door of the house at 11, 12 o'clock at night?
Well, front door of the house, as you know, with any type of kids, you want to try and keep the kids sleeping as much as possible, especially on school nights during tax season. It is late. She'll get home. As you know, accountants work extremely late. And then in addition to that, she does occasionally have a private person that she'll do taxes for, come over and visit, and then sit down with them and do their taxes, rather than having them parade through the center of the house to go up to the computer area to sit down and go over taxes. That is the reason why it would be more beneficial for them to come up an outside area. Also for fire and for egress purposes, if you're up there, it's easier to get out of the house for life safety reasons via a back staircase rather than to go down the staircase and then through the house to get out the front door. So for life safety reasons, that would be a substantial reason too.
Okay. Gentlemen, any questions?
No, thank you.
Okay, thank you. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved.
Second.
Vaguely moved in second. All in favor?
Aye.
Aye. Motion carries. Next case is case 1-16355, Margaret Cheshire, 69 Locust Drive, Kings Park. Location, east side of Locust Drive, north of St. Johnland Road, Kings Park, property zone R10. Request a special exception of the zoning ordinance to permit a temporary living quarters for a parent existing. Variance of a special exception to increase the maximum permitted living space from 600 square feet to 765 square feet existing. Reduce the maximum occupancy in the rear yard from 700 square feet to 765 square feet. Increase the maximum accessory structure height from 15 feet to 18. Reduce the minimum side yard from 12 feet to 5 existing. Increase the maximum paving in the front yard from 25% to 30 existing. Increase the maximum paving in side yard from 25% to 50% existing.
Good evening, Madam Chairwoman, fellow board members. My name is David Altman. I'm with the firm of Brown & Altman, LLP, 510 Broad Hollow Road, Suite 110, Melville, New York, for the applicant. Madam Chairman, just as, I guess, a little refresher, this is a continued hearing. The applicant appeared before this board on February 22nd, presented its application in chief with respect to the proposed special use permit sought, as well as the variances that Madam Chairman just noted for the record. At that time, a planning advisory report was not in hand. The record was closed. However, applicant did not have a chance at that point to review and respond to the planning advisory report. We had asked that we have the opportunity to do so. The matter was then placed on this board's, I believe, April 26th calendar. We did not receive the planning advisory report until a day or two before the hearing, and I had asked to adjourn it, again, for purposes of review and to be able to respond to the planning advisory report. Ultimately, we wind up here tonight, and I'd like to thank this board for its courtesy of adjourning the last request. I believe the matter was placed on the second hearing in May, and I was unable to attend at that time due to scheduling conflicts, so I'd like to thank the board for accommodating the applicant
Just a
tonight.
matter of correction, all the PARs are only delivered about two days before the... Okay.
I'm aware of that, Madam Chairman.
Okay.
Thank you.
Go ahead.
So, having reviewed the planning advisory report, and I'll take out a copy of that report, I'd actually like to start with item 9 in the planning advisory report, which are the variances noted in connection with the application. I believe that appears on page 2 of the advisory report, Madam Chairman. The first variance that's noted, and as you had noted for the record, is to increase the square footage of living area from 750 square feet permitted to 765 square feet existing. I would submit to the board that in connection with this increase, it is minor or de minimis. You're talking about roughly a 2% increase or variance over what is permitted. With respect to the increase in the height of the existing structure or accessory structure, the code permits a 15-foot height. The existing structure is 18 feet. As I noted, Madam Chairman, when we appeared before the board on February 22nd, this structure was existing. It was initially permitted and approved as a garage and received the C of O as a garage. The applicant has made no additions, alterations, excuse me, or changes to the height of the structure. This was an existing structure at the time, and in fact, I believe did receive a permit and again a C of O at that particular height. With respect to the next variance item, which is to reduce the side yard from 12 feet to 5 feet, I will note in the planning report, and I believe this is correct, that that particular side yard setback variance is in fact erroneous. The actual required side yard setback should be 6 feet, not 12 feet. It's 5 feet that's provided, and I would submit to the board that, that being said, the variance sought based upon the existing location of the structure would be a 1-foot variance or de minimis in nature. With regard to the driveways, I would note again that the existing paved area, while approximately 50%, Madam Chairman, this lot is approximately 33% larger than most of the other lots noted in the San Remo area, and that's duly noted at page 1 of the Planning Advisory Report. We had indicated, and I had indicated at the first hearing, that we would be willing to provide any reasonable landscaping requirements up front to sort of mitigate the impact of the existing pavement in the area, including with respect to mailboxes, we can consolidate down to one mailbox. I'm again reading at page 2 of the Planning Advisory Report. That addresses most of the variances, if not all of them. And I would submit, Madam Chairman, that with respect to the variances and the balancing test as displayed on the piano next to the board, it does not have an adverse effect on the character of the area. This has been an existing structure, and from my understanding, an existing use of the structure for the better part of 12 to 13 years. In fact, the board may recall that when the applicant appeared before this honorable board on February 22nd, the applicant submitted a petition signed by 16 of the applicant's neighbors in support of the petition, all looking favorably upon it, and in fact one resident who lived, I believe, catty-corner to the property actually appeared and testified in support of the application, stating, and I'm paraphrasing, that he thought the structure looked fine and it was a benefit, in fact, to the character of the neighborhood. With respect to whether the benefits sought can be achieved by another means, respectfully, no, Madam Chairman, this is an existing structure, and in order to in order to eliminate the need for variances, would either be a partial deconstruction and relocation of the structure. I'll submit that, as I just indicated, that the variances are not substantial. They will not have an adverse environmental impact on the character. Again, you have a use that's been in existence for the better part of 12 to 13 years, and I'm not aware of any complaints or violations of an environmental nature being noted as part of the record. And again, you have a number of neighbors who live proximate to the site actually speaking in support. Whether the difficulty was self-created, I would acknowledge in part, certainly. The use was, in fact, in existence at the time the applicant purchased the property, circa 2005. Unfortunately, did not have the appropriate permits for the proposed special permit that we seek here this evening. Now, one of the criteria, as the board is aware, that and that is noted in, I believe, at page 1 of the planning report, is the location of the entrance to this temporary living quarters for a parent. Right now, it's situated on the, I believe, the front of the structure facing the street, Locust Drive. When I appeared before this board and the applicant appeared before the board on the 22nd, we had indicated that we would, in fact, relocate that entrance to the side of the structure and make the facing, or that portion of the structure which faces the street, uniform such that it does not have the appearance of, in fact, an entrance there. And I have an estimate from a contractor to do the work, and the applicant is certainly willing to do it, Madam Chairman. I'd like to submit that estimate into the record.
Okay. I'll look at this. You can look at this, if you like.
The approximate cost is noted in that estimate, Madam Chairman, to close up the existing doorway and create another one on the side of the dwelling is approximately $1,500, and the applicant is certainly willing and able to do that. In addition, one of the conditions for the temporary living quarters as part of the special permit is that the structure be restored to its original condition, in this case, a detached garage. The planning advisory report notes, I believe at the top of page 2, that for some reason appears to be a practical or economic difficulty. I would submit to the board that the basis for that particular comment is not contained in the report, nor is there any factual support for it. In fact, the structure can, in fact, be restored to a detached garage when the applicant no longer resides there, and the applicant has stated her willingness to do so. In fact, during the February 22nd meeting, I indicated to the board, and I'll reiterate again, the applicant is willing to execute a covenant containing reasonable conditions to restore the structure to a two-car detached garage following the cessation of her occupancy in there. And I had even pro-offered, perhaps against my better judgment, the right as a condition as part of that C&R to allow for an inspection to make sure that it in fact is being occupied by the owner. Finally, we also have an estimate from the same contractor with a cost to in fact restore or deconstruct the structure from living quarters to a garage, and I have a copy of that estimate. I'd like to submit that as well, Madam Chairman.
Mhm.
For the record, Madam Chairman, the estimate provided by the contractor indicates the approximate cost to deconstruct and, I guess, convert the structure back to a two-car detached garage is approximately $15,775. I will state for the record the applicant has the wherewithal to do so financially, and in fact, I'll even note for the board that the equity in the property in and of itself is sufficient to financially ensure that once the applicant no longer resides there, that the structure is restored to a garage. The applicant purchased the property in 2005 for approximately $515,000, even taking into account a worst-case scenario in terms of property devaluation given the current economy. The applicant believes the house to be worth somewhere in the neighborhood of $400,000 to $425,000, and the value on the existing principal on the existing mortgages is approximately $289,000. So there's more than sufficient equity, God forbid, that the applicant can resort to in terms of restoring or deconstructing the structure. Finally, Madam Chairman, I will note and for the record, and I'll provide to the board a letter from the applicant's treating psychiatrist. I know this is no longer a condition as part of the special use permit criteria, but in fact it is something to be borne in mind by the board. I had indicated last time that the applicant's treating physician, psychiatrist, thought it was in her best interest to remain in the house for a number of reasons, many of which I obviously can't disclose for I guess privacy reasons, medical privacy reasons, but I have a letter from Dr. Juliana Kanji with an office in Park Avenue in Huntington. She is the applicant's treating psychiatrist, and I'd like to submit that into the record as well.
Okay. Thank you.
Finally, Madam Chairman, I'll note I've discussed the planning memo with Deputy Planning Commissioner Dave Flynn on a couple of occasions, and particularly the mitigative or ameliorative measures that I've noted for the record tonight and previously noted on February 22nd. And in discussing that with Deputy Commissioner Flynn, he was of the opinion that the ameliorative measures as described would be sufficient or should be sufficient and taken into consideration by the board. I just simply add that for the record. I have no further comments, Madam Chairman.
Okay. Planning? Gentlemen? Nothing? Okay. Okay. Is there anyone here that would like to be heard on this application? Hearing none, I'll entertain a motion to close the hearing.
So moved. Second?
It's rarely moved in second. All in favor?
Aye.
Aye. Opposed? Motion carried. You're welcome. Okay. That concludes the hearings for tonight.